Hey guys, how's it going? Joe Brunsman here again. Immediately following my presentation, I get an email that a number of the members of your group wanted a summary of basics in insurance coverage. And so, yes, it's important that you get the right thing in your policy, but that's really only 25% of what I want you to take away here. So I thought I'd just make another video. For the time being, only you guys with the link will be able to watch this video. So this is just for American Co-op. And with that, I wanted to hit the highlights. There were some things that I just could not cover given the time limitations. So you can take this video, you can watch it now, you can put it in your calendar, you can watch it again when renewal season comes up. And hopefully this will help keep you guys out of trouble. Now with that, there are effectively 4 parts of every policy that I want you guys to understand and be aware of, and kind of some tricky points and some pointers that I wanted to give you guys as you move forward here. So we're going to be talking about the application, the policy proper, looking at what's inside of it. Next is going to be policy compliance, and the third is going to be policy defense and risk transference. So the application itself, what do I want you guys to know about this? Well, there's definitive questions, which could require definitive answers. A lot of the questions you're going to see, they may not have an explanation box. It could be as simple as check yes or no. And as a former tech guy myself, I can tell you life's not that simple. You obviously know that now better than I. And so with that, you just have to be careful. And you have to understand that when you're putting together an insurance application, you're applying for an insurance contract. It's a legal contract. So that should add a little more gravity to what we're talking about here. Now, definitive questions could require definitive answers. Some of those questions may be impossible. So for example, if you get some question that says, are you compliant with all applicable state and federal cybersecurity and privacy laws? How do you even begin to answer that question truthfully? So let's say you hit every benchmark on NIST-CSF. Well, at some point in the year, something is going to go down, something is going to go sideways, or you may have clients where every single one of your client has XYZ controls except for that one guy. So with that, don't be afraid. You can add an addendum to your application. Now, what are we trying to do there? If something falls kind of in a middle ground, give the explanation to the underwriter. We're trying to put the legal onus back on the underwriter to ask the appropriate follow-on question, as opposed to you fitting 100% into one box or the other. So don't be afraid to add an addendum. It's a very powerful tool, constantly overlooked, and I really recommend all of my clients use that tool if they're ever in a situation where they need to use it. Next, start thinking about liability there. So when you're answering these applications, yes, you need to be 100% forthright with your answers, but no, you may personally not have all the answers to those questions. So even as the business owner, you may not know all the questions there. So you can start bringing in multiple people in your team. So maybe you need the head of HR, maybe you need the CTO, the CIO, the CISO, so forth and so on, to start hashing out those questions. I have seen it in the past where the owner answered a question that he thought in good faith was true, but then it turns out in this specific circumstance, there was a new head of HR, and she actually hadn't gotten the memo that she needed to talk to IT before someone got fired so they could revoke access as the person was walking into the CEO's office to be terminated. So you have to be careful and don't think like you have to do all of this yourself. It could require other people. So that's another reason why it's better to start early and actually hash this stuff out, because it really is important for you, especially when we look at the current legal and insurance landscape. It's getting really tough out there for you guys. So please take your time, make sure it's done appropriately. Generally, the application sections, you'll see organizational, technical, policies and procedures, and then, of course, legal and compliance. If you want to see what happens if you don't answer a question 100% in line, given various technical controls, check out a copy of my book. I sent that to Brian. Look up the case Columbia Casualty v. Cottage Health Systems. That was about a $4.5 million mistake there. Now, what actually brings trouble? I get this question a lot, and ultimately, it depends on your business. It depends on what you said. It depends on what the application asked. But generally, we're trying to avoid something called a material misrepresentation. So I'm just going to read verbatim here. In an insurance contract, a material misrepresentation occurs when the insured makes an untrue statement that is material to the acceptance of the risk and would have changed the rate at which insurance would have been provided or would have changed the insurer's decision to issue the contract. Now, what's the remedy here? The insurer's remedy upon discovery of a material misrepresentation is rescission of the policy. What does that mean? They're essentially going to rescind the policy. They're just going to cancel it right there. So let's say you have a claim and you failed to report a potential claim before you've renewed. They'll consider that a material misrepresentation of something that you put on your application. We're going to talk a little bit more about that here in a sec. And because of that, you won't have coverage. So if you're more interested in this particular topic, the Journal of Insurance Regulation, I may be the only guy actually nerdy enough to read that, but you can go to the actual source material right there if you want some further interesting reading material. Now, also on that application, you're going to be putting in your revenues. And this is something that really annoys me when insurance guys don't tell people this, because it really is quite important. Now, gross weighted revenue, what are they going to ask for generally? Hey, what was your revenue last year, this year, and what's your estimated revenue for next year? Now, next year, that's just an estimate. So I'm not saying lie, but what I'm saying is be truthful but conservative in your estimation there, because I'd say especially now, like, who knows what's going to happen next year? We could have a stock market crash. We could have an economy booming like we've never seen before. So like nobody really knows. Generally, I just tell my clients, hey, just keep it flat, maybe 10% for the MSP community. That's fairly average. But you don't want to count your chickens before they hatch. And I have never seen a tech insurance provider go back and audit those estimated revenues. It's not like workers' comp, for example, where they'll go back and audit it and charge you more again. So ideally, be truthful but conservative on that estimation. Why? Premium equals rate times gross weighted revenue. What's the actual formula for gross weighted revenue? It depends on the actual insurance company. They all have their different way of doing it, but it's some percentage combination of last year, this year, and next year's estimated revenue. So if you just have some crazy estimation because you're like, I don't want to underestimate this because then I'm going to get in trouble with the insurance company, you're just throwing money out the window. So be truthful but conservative there. Nobody really knows what's going to happen in the future. All you're really doing, if you completely overestimate by some massive degree what next year's revenue is going to be, is your insurance guy gets paid more and the insurance company makes more money, and you are just throwing money out the window. All right, next, I get this question all the time. Hey, what limits do I need? Well, you guys are fairly large, so it's a different conversation with you, but ultimately it depends. It depends on your exact MSP. Let me just kind of go through the items here. It depends on your business. It depends on what policy features you have. It depends on your particular risk tolerance. It depends on contractual obligations. It depends on your own internal controls. Excess insurance could be a factor here, depending upon all of the above and what it is you need, what your revenue is, who your clients are. And ultimately, we want to keep you in what's called the Goldilocks zone. So you need enough insurance that you look responsible. You need enough insurance to meet all the above, but not so much insurance that a plaintiff could keep you in court forever. What do I mean by that? Well, generally, your insurance limits can be discoverable by the plaintiff via subpoena when a claim arises. And so let's say the plaintiff's attorney is working on a contingency fee basis. So they get some percentage cut of whatever the award is. Well, if you have just some outrageous amount of insurance, so let's say you're like, hey, if I don't have 20 million in tech E&O insurance, I just can't sleep at night. That can actually work against you. So you have to be careful. Keep it in the Goldilocks zone. You don't want too little. You don't want too much. What that Goldilocks zone for your business is, it just depends. We would actually just have to kind of talk through all of these features, and it's going to depend on what what actual policies you can even get given the current marketplace. We'll talk about that here in a sec, but just kind of keep that in mind. You got to keep it evenly weighted. All right, next, let's talk about the actual policy, which was the heart of the question here. Once again, this is going back to my actual presentation. Two sides of a tech E&O policy. The first is going to be third-party coverage. That's E&O coverage. Somebody wants money from your business. That could be your clients, your vendors, regulators, some other third party, right? Somebody wants money from your business. The other side of tech E&O is going to be first-party coverage. So that would be you. Those are expenses you would pay for, oftentimes legally obligated to pay for, if you didn't have the insurance. All right. Within cyber, there's ultimately 4 buckets. There's going to be coverage for a breach of your system. There's going to be coverage for ransomware events, some type of loss of funds, and then miscellaneous but situationally important. So on this next part, excuse me, if we're talking about third-party coverage, so we go back here, your clients, your vendors, regulators, other parties that want something from you, generally money. This is the most crucial part of that. Professional services. You render some type of professional service. Through rendering that professional service, right, but for the action or inaction of rendering those services, there's some alleged wrongful act that has been committed. Because of that alleged wrongful act, a claim is brought against your firm. Now, here's an example from a miscellaneous E&O policy, and this is why this is so important. Because if we go back here, you'll see the heart of all of this is professional services. If you don't get that part right, everything moving forward, like, you're just going to be screwed. That's when you're going to see declinations of coverage, partial declinations of coverage. That's not a position you want to be in. So here you'll see this is just a terrible example. Solely in the performance of services as computer consultant, management consultant, telecommunications consultant, and staffing services. Now, even if we construe those as broadly as possible, I think it's very hard, even if you were going to try and fight this, like via bad faith claim following some type of declination, it's going to be really hard to argue that what you're doing as a large, sophisticated MSP would fall within the bounds of something that narrowly construed. So once again, you have to be careful because claims which allege wrongful acts for services not defined as professional services are unlikely to be covered. And even if you can go back and you can successfully prosecute a bad faith claim, that's going to take a lot of time. It's going to take a lot of money. And in the interim, you're going to be out a whole bunch of cash. So you want to make sure you get it right on the front end. Here's an example of how you get it right on the front end. Now, professional services means here technology services and internet services for others for a fee. And there's actually a hidden element in here I'm going to show you here in a second. And this is a great place where you can just pause. You can look at what services you're rendering and see if it could reasonably be construed to fall in this. This is one of those elements where when I'm sitting down with a client at their renewal or their brand new client, this is one of those crucial elements that it's, hey, all stop. We got to look at this. If we mess this up, this is going to be bad. You got to tell me if there's anything you're doing that wouldn't fall within these bounds. So you'll see here, and there's going to be 3 parts to this. Technology services means IT services performed by and insured for others, and now including but not limited to. And why is that really important? Including but not limited to drastically broadens what's going on following that statement. This gets into something I talked about in the presentation, contra preferentum, which means that ambiguity is construed against a draftsman. There's a number of ways that policies are actually interpreted, but this is kind of one of those key elements where you can see the insurance companies going, hey, we're trying to make this as broad as possible. Now, including but not limited to, what does that mean? Pretty much everything under the sun. So like anything loosely construed with what you have going on here, I think could reasonably be construed as a technology service. Now, this is important because you're not having to fit everything within a little box. And if you don't fit within that box, you're going to be in trouble. This is super broad. So you want to look for terms like that, which kind of in insurance parlance transforms this from a named peril to somewhat more akin to an all risk type policy. So you can see we got a bunch of stuff going on here. And then of course, sale or distribution of technology products. That's actually defined a little bit later. That's the hidden element I was talking about. You'll see internet services here and then technology products. Now let me move my little beautiful face here. Technology products means computer or telecom, hardware or software products, related electronic products, created, manufactured, developed by the insured for others, or distributed, licensed, leased, or sold by the insured entity to others. So in that particular case, let me move on back. In that particular case, you're looking at this and you're going, okay, are we doing technology services? Are we doing internet services? Or are we offering any sort of technology products? That's going to be super crucial for what you're doing. So please make sure you take just a wide canvassing of what you're doing. See if it fits within this. If you're doing something that doesn't fit within this, or whatever professional services are defined as under your policies, once again, you're going to have a very hard time. Everything else moving forward, it doesn't matter how many policy widgets you have, you're going to be in trouble, and that's going to be a very large dollar loss on the horizon for you. All right, now moving forward, this is a recent Tech E&O breakdown. And so when we talk about policy features, this is just an example to show you that one, not all the policies are the same here. It just depends on who's offering what at what time. And you can just take this list and you can actually kind of start going down. Once again, it's the 4 buckets. What do you actually need in your Tech E&O policy? It just depends. We have to have that conversation, but it depends on what you're doing, who you are, what your risk tolerance is, how you're set up. So for example, let's say you have cloud-based services. Let's say everything you're doing, it's based out of AWS. Well, if AWS goes down because of that, you can't make money. That's where something like dependent business interruption, dependent system failure, business interruption reimbursement could be a lot more important to you. Whereas let's say you have all the servers in-house there and everything's run off that server, you have nothing in the cloud, then something like bricking coverage is going to be a lot more important to you. Now, there's kind of some situational items in here. Besides that, something like first and third party bodily injury, property damage, generally not super important for an MSP, but we talk about that anyways, just in case. But you have to know what's in your policy and why that's important. The other issue here you really have to be aware of is something called a waiting period. Now, a waiting period, that generally goes into this dependent business interruption reimbursement coverage, as well as something called reputational harm. What is reputational harm? That is, let's say something happens. We'll go crazy. We'll say some software you're using allows a backdoor. Bad guy goes through your RMM, hits you and all of your clients with ransomware. Then you have a bunch of clients that leave following that event because now they're angry and they're going to go find an MSP somewhere else. Well, reputational harm is for a set period of time. Period of indemnification is generally how it's labeled there. That is how long the insurance company will reimburse you for the difference between what you were making before the event and what you're making after the event when all of those clients left. Now, that's really important, especially for a large MSP, because, let's say one monster client leaves, you don't want to have to start laying people off. So you have to make sure that you have the appropriate period of indemnification, also the appropriate waiting period here. So you'll see something like 8 hours, 12 hours, that's fine. Something like 24 hours before you start getting reimbursed, that's a little bit more to stomach there. I've seen it all the way up to 5 days. Personally, I saw a quote like that. Obviously, that never got released to the client. I've heard reports of municipalities getting cyber policies where the waiting period was 3 weeks, which is particularly egregious. So you want to make sure that you understand what those waiting periods are, period indemnifications. And of course, if that's something that you're particularly worried about, then that's going to factor into the overall limits that are going to be appropriate for your business and how the actual policy structure is stated. Now, I can't go into that here because it's just too technical and I've already been talking for like 20 minutes. But take these little line items here, just start kind of going down the list, figuring out, okay, what's important to you? What do you need? Now, a quick market snapshot as of just making this video. It's getting rough, frankly, out there. So like CFC's out, AppA's out, Hiscox is out, Beasley, they're taking a break. slash they are completely out from quoting any new business. RLI, they're getting a lot more strict on the criteria before they offer a quote. They also have minimum premiums. USLI, moderate criteria that I've seen, still looks like minimum premiums. New company out there called Celerity, stricter criteria, minimum premiums. Scottsdale E-Risk, they've kind of just gone off the deep end. They had a really fundamental policy, not appropriate for business of your size, but they're looking at what appears to be like a minimum $12,000 premium and much stricter criteria. Others, that's when we start getting into some of the other markets, like the bigger multinational players. Generally, those are looking for a minimum of $25,000 in premium, which, all things considered, not bad. Like if we took, let's say whatever your revenue is, if you were say like an A&E firm or a CPA firm, your premiums are probably still going to be a lot higher than what you're going to see here. But moral of the story is you have to start early on this stuff because the market's really in flux at the current moment. And because of your business size, you may actually get special treatment. So there's certain things where, like key personnel provisions that will help with potential claims. Rogue employee carve-backs, if you're worried about that. There's a bunch of kind of like little interesting nuggets that we can do that would make the policy a lot safer for you. But regardless of who you go with or what you're going to do, you got to start early on this process to figure out all of these different moving parts. Now let's briefly talk about policy compliance for a sec. Policy compliance, there's a lot to it. I can't hit every single widget here without putting everybody to sleep. It's really going to depend on what you're doing. That's kind of a conversation after the policy quote gets issued to you so we can work through all of those little subtle nuances, but there's kind of some key elements here you need to be aware of. How being a good person could conflict with your insurance requirements. We briefly touched on that at the very end. The difference between something that's your fault and your problem, and then loss of funds. Are there specific rules to that? So you want to make sure that you understand all this. Some of these policies, they could have specific rules in that loss of funds, like a social engineering type coverage, on these specific criteria have to have been met before the policy will reimburse you for that. That could be pre-established callback numbers. That could be speaking with a known entity. And with that can actually fundamentally change your internal controls, because if you know, hey, anything over 25 grand, it has to have these controls in place. That's when we have to bring in your CFO and start talking to them or your comptroller or your controller to make sure that they understand the rules of the policy. It's not just, say, the bigwigs, the CEOs that understand it, because it can impact multiple parts of your organization. Now, this is one that I talked on, 3 exclusions that could screw you. That's admitting liability, settling without insurer consent, or making voluntary payments. Please don't do that. Generally, when you have a situation like that, that could actually be a potential claim. So don't fall into the mistake of being a good person, arguably, and inadvertently voiding your insurance policy. I have a whole video on that, by the way, if you want to watch it. Now, the biggest kind of takeaway here in terms of compliance is when it comes to insurance, you're most likely going to screw yourself. And this is the whole idea of a potential claim. Now, I won't bring up the policy language like I did during the presentation, but even if you say something like, hey, it isn't my fault, okay? Well, it kind of doesn't matter because it could still be your potential problem. Now, as technically minded people, what happens when something goes wrong? Right? Well, maybe immediately we're angry, but then like the technical side of our brain takes over. Something happens at a client and you start going through that checklist, right? It's, okay, what was in the MSA? What was in the SLA or the statement of work? Was there something that we missed here? Or was this completely the client's problem? Well, or completely the client's fault, excuse me. Even if it was completely their fault, it doesn't mean it's not your potential problem. So for example, client gets tricked and they wire money. I've seen that claim. Client gets hit with ransomware, completely their fault. I've still seen the MSP face a claim over that. Next, clients experience some type of cryptojacking. That could be another example for you. I haven't seen that one personally. I've only read about it. But even then, that could still potentially be your problem. And so the issue here is this could be construed as a potential claim. So there's claims and there's potential claims. Most people don't miss claims. You still need to understand what that means. It's not just a lawsuit. It could be a demand for arbitration mediation. There could be a whole list. There will be a whole list inside of your insurance policy that we need to go over to make sure you understand what those elements are and at what point that has to be essentially required to be given to the insurance company as notification of a claim. There's various different ways that it's worded that kind of play out differently. Most people don't miss claims. What you're probably going to miss is the idea of a potential claim, because you're going to go, hey, this wasn't my fault, therefore it's not my problem, no one has sued me yet, and therefore I have nothing to say to my insurance company. Well, it's not that simple, because generally the way these policies work, right? Remember when I talked about material misrepresentation? Generally the way these policies work are if you know of anything which may reasonably bring rise to a future claim, you have to report that before your policy renews, or as soon as practicable, or as soon as reasonably possible. There's different ways it plays out. We have to talk about that exact policy form. But the gist of it is, hey, if you have something that's a potential claim, that probably needs to be reported right away. And there's kind of some issues with this, all right? And we could talk for 20 minutes about this particular topic. But you could say to yourself, hey, what if it's under my deductible? Well, there's other issues involved here. So what about punitive damages assessed against you? Defense costs that could come up if there's a claim here. Bad publicity, loss of other clients. What if you pay for something because it's under your deductible and then the client turns around, sues you for something else, and because you've already paid to make that problem go away, now you fall into this problem where you have inadvertently just voided your own insurance policy. You don't want to do that. Now, moving back here, just because it's under your deductible doesn't mean it's not necessarily a potential claim. There could be underlying issues there. So as we often say here in my office, where there's smoke, there's fire. You want to preserve your policy rights. Now, if you start, effectively putting in these potential claims, I understand as a fellow business owner, I have my own E&O policy. I get it. The immediate question always is, hey, is this going to increase my premiums? Well, yeah, that's possible. It is absolutely possible. It is possible that the insurance company is going to go, hey, you have this potential claim here. Because of that, we're not going to renew your insurance policy. You got to go somewhere else. That's entirely possible, but we can deal with those premium increases. We can always try and find a different insurance company, right? That's where the broker has to come and play to really advocate for you to say, yes, they had this potential claim. They were adhering to their policy requirements. They take this seriously. Because of that, they're actually a good risk. And hey, here's what that potential claim actually cost. Maybe it could have been $0. You put it on the books just to preserve your policy rights. There's a number of features and considerations that would go into whether you're going to report a potential claim or not. We kind of got to talk about that. It's fact pattern dependent, depends on the case, depends on your relationship with the client, what exactly happened. But you always have to think to yourself, how well can you deal with an uncovered claim? Claims expenses, damages awarded to the plaintiff, all that type of stuff. Generally, that's going to be a lot more expensive if you have to deal with that claim out of your own pocketbook than it is to deal with some type of premium increase there. So please, when in doubt, preserve your policy rights, comply with the policy as written. Every policy is going to be different on how soon you have to report something, at what point when someone knows about something in your business, then it's considered known knowledge that you have to report it. It all boils down to the specifics of your policy, but you need to make sure you understand what that is. You should be trained on that appropriately so that way you can play the game. So remember, before you renew, does anybody know of any potential claims? I can go all the way down to the newest tech, that L1 tech who's just sitting there taking those trouble tickets. Anybody know of any potential claims? Next, does anybody know of any claims? Make sure you read your policy, please. I know it's interesting for me. I nerd out on that stuff. I know for you it's not super interesting, but you need to read your own policy, and ideally you have an insurance guy that actually train you on this stuff to avoid a lot of these pitfalls. There's some other potential pitfalls in there, but I just don't have time to talk about it here, or I will be here forever and people will stop listening. All right, now that you actually know how to play the game, that's important, right? Before, right, a lot of people get scared when I talk about this stuff. Well, the scary part is you didn't know any of this before. So you couldn't even play the game because you didn't know the rules. But now at least you know most of the rules of the game, so you can effectively play the game. That's going to be important for you. So don't be scared that you know it. You should be more terrified you didn't know some of this stuff before you watch this video. All right, policy defense and risk transference. What do you need to understand here? You need to understand that what you do is so technical that if you get sued, there's probably going to be a settlement, right? Whether that's a baseless claim or not, whether you legitimately did something wrong or not, whether it was your fault or not. What you do is so technical, you're now falling into the same trap that all of your other white-collar professional peers have fallen into. You get paid very well because what you do is highly technical. And trying to explain that to a jury of 10, 12 random people that didn't get out of jury duty is just going to be pretty damn difficult, nay impossible. So with that, you need to start thinking, how do we put things in common terms that we can start pushing back against these claims when clients do something stupid, that we can push back against this to say, hey, we tried, right? We tried to warn them. We put all of this material in front of them. We warned them time and time again over a period of potentially years. Well, there's a lot we could get into here, but I would just say I have an entirely separate video called Get Smart Defense in Depth for Your MSP. I'll link to that up above. Next, hey, what happens when clients don't want to listen, when they're just completely obstinate or pig-headed, and you're like, hey, you got to do this thing. Can you have liability waivers? These are actually known as exculpatory agreements. Can you do that? What are kind of the general rules surrounding that? I have an entire video on that as well. I'll just link to that in the description below because there's way more to it than you would think. It's not as simple as saying, well, hey, I warned you, so make sure you sign this document that I ginned up that says, I warned you, you still don't want to do it. Anything that happens isn't going to be my fault. It's not that simple. There's definitely more technicality involved with exculpatory agreements. A lot of it depends on the state, which is also going to go back to your MSA or that statement of work on what the venue is going to be given some type of dispute amongst the two parties. That's going to play a factor as well. Some of those exculpatory agreements, once again, it depends on the state. Some of them have to be very strictly construed or it's going to be held against you. So not something that you just necessarily want to dabble in or write yourself because that could really come back and bite you in an expensive way. Next, limitation of liabilities and contracts. How good are they? Are they important? Do you need them? I'll link to this in the description below as well. And then, of course, why hiding a data breach is a very bad idea. That's both for you and your clients, something I want you guys to consider. Okay, so with that, please start early. Next, work with a specialist. This is not a traditional area of insurance. This is new and it's ever evolving. So you have to make sure that you know what you're getting into there. Under the application, add that addendum as necessary. Assess the definition of professional services. Assess the policy features versus your unique needs. Understand limits and sublimits in your policy, how those actually work. That can have a very large impact to you and could potentially lead to a very large uncovered loss if you don't do it correctly. Think liability and compliance. Start working on that risk management and risk transference, that policy defense. The sooner you get those elements in place, the easier it's going to be for you to start fighting back against those claims because once again, if you get sued, there's probably going to be a settlement when a claim hits your desk. Why? What you do is so technical. So you want to make sure that you have that defense in depth, you have that ammunition where you can reasonably start pushing back against those claims that, frankly, they are coming your way. To be somewhat blunt here, you can just look at the insurance market. You don't have to trust Joe. Premiums, they're increasing at a fairly rapid clip here. That's the big brains that the insurance company is going. There's a lot of risk here. We're seeing a lot of claims in this particular area. Insurance companies are losing a lot of money. Hence, the risk is out there. All right. With that, and I'll end with this. There's more to the story. This was like the 30,000 foot view, the 80-20 of what I think you guys should know. given the question that you posed. All of this is going to depend on your business. It just takes a conversation to figure out, okay, what actually is important to your business? Because some other MSP out there, they could have the same exact client base. They could have the same exact revenue per year. And you guys can end up with two totally different policies because it depends on a number of factors that I can't really get into here. So these were just the highlights. If you have any questions, that's my email address. Stay safe.